Hello all, hope you guys are all well and safe and having a great week. Tonight, Middlesex University Product Design Engineering and Design Engineering are really excited to host our 11th talk in the annual guest lecture series. These run weekly throughout the academic year on Thursday evenings, and they bring together a vibrant mix of speakers across the full spectrum of design and design engineering. Tonight, we're really excited to host Anna Bools and Philip Slingsby. They're joining us from Slingsby Partners LLP. So a little bit about Philip. He's a patent attorney and the managing partner of Slingsby Partners. He specializes in obtaining protection for inventions and designs and advising businesses and designers on how to maximize the value of their intellectual property. Philip has a lot of experience, over 25 years of experience in license negotiation and representing clients in IP, in intellectual property, both nationally and internationally. And Anna Bools, she's a part qualified patient attorney. Her background's really interesting. She's completed a physics degree at the University of Exeter. And Anna joined Slingsby Partners LLP as a trainee. She's been there for almost 3 years now. And she has a lot of experience in terms of prosecuting patient applications in countries worldwide, and primarily in the fields of graphic processing and healthcare technology. We share the details of the talk and Anna and Philip to your emails ahead of today, including links to the Slingsby website as well. So definitely feel free, guys, to have a browse on the website, learn more about their sector expertise, more about the clients and the services Anna and Philip and Slingsby Partners offer. And without any further ado, Anna Bools and Philip Slingsby with the talk titled Intellectual Property for Designers. It's all yours, guys.
Hi. Yeah, so we are from Slingsby Partners, which is a small firm of patent attorneys, usually based in Holborn in the West End, but obviously at the moment we're all at home. Most of what we do is focused around advising clients as to how they can best protect their designs and inventions and sort of organising getting that protection for them. The aim of this presentation is to give you a brief overview of what intellectual property is and how it might be relevant to you as designers. So what is intellectual property or IP? One dictionary definition I found defines IP as intangible creations that are a result of human creativity. So in other words, ideas rather than physical things. It might be an idea contained in words, a logo, or in your case, probably an object or product. The law has a number of mechanisms which you can use to protect these sorts of ideas. And by protect, I mean that you can prevent other people from exploiting that same idea. In the UK, these main types of IP protection are copyright, trademarks, patents, and design rights. Before I started this job, I didn't really understand what all these types of protection were, but it's definitely a useful thing to know, I think, in general life, but also especially if you're in the business of coming up with new designs and products. So first I'm going to talk about copyright, and I've got a short video clip to help with the explanation of what copyright is used to protect. Oh, sorry. All right. Okay, so copyright is used to protect literary, dramatic, musical, and artistic works. So obviously in that video you had a song which has both music and lyrics. The copyright to the music is owned by whoever composed that, and might be different to the copyright which is owned by whoever came up with the lyrics. There's also a dance which is considered to be an artistic work. and the choreographer of that dance will own the copyright to that as well. Other things which copyright is used to protect will be things like books, paintings, songs, films, things like that. The protection for copyright arises automatically. That means that as soon as you've made your film, written your book, etc., you own the copyright to that thing. Unlike some other types of intellectual property we're going to talk about, there is no need to register this right anywhere. It just arises automatically. The protection afforded by copyright means that the owner of the copyright, the author, composer, etc., can stop other people from copying their work. Someone who has or is copying your work is said to be infringing upon your copyright. If you wanted to enforce your copyright, you could take the infringer to court. The protection lasts until the author's death, plus another 70 years. And after that time, the work enters the public domain, which means that anyone can reproduce it without infringing the right. This is often referred to as being out of copyright. So next up is how you protect your brand. A way you can do that is using trademarks. Trademarks are used to protect signs, where that sign indicates the origin of a product or service. So, for example, a logo. If you buy a pair of shoes with a swoosh on them, that signals to you that they've been made by Nike. Unlike copyright, trademark protection doesn't arise automatically. We recommend that to get the strongest protection, you file an application to register your particular sign as a trademark, and that'll be with the Intellectual Property Office of the relevant country. The aim of having a registered trademark is to prevent competitors from using the same sign as yours, or a very similar sign, such that it causes confusion between the two origins. One of the reasons behind wanting to protect your sign is that were a customer to purchase a pair of shoes which had a swoosh drawn on them, and they turned out not to be of the quality that the customer expected. For example, if they had already had a pair of Nike shoes and this pair of shoes just weren't as good, not only would Nike have lost that customer's purchase, but there might be long-term damage done to their reputation, and therefore potential loss of future sales as well. A sign in trademark terms doesn't just have to be a logo, but it can also be the shape of a product. A shape can usually only be registered as a trademark where that shape has become so entangled in the company's identity that a company would be sure they were purchasing from that company, that a customer would be sure they were purchasing from that company if they bought an item having that shape. So, for example, if you bought a chocolate bar looking like this, even if you couldn't see the lettering and it had no package on it, you'd be pretty sure you were buying a chocolate bar made by Toblerone. And so, as I said, unlike copyright, protection for trademarks doesn't arise until that trademark has been registered with the Intellectual Property Office. The IPO has a register which you can look at online. And if you hold a registered trademark, you can take legal action against someone who's using your sign, or someone who's using a sign very similar to yours, if that's likely to cause confusion. So next up is patents. Patents are used to protect inventions, only when the patent's been granted. So in order to get a patent granted, you must file a patent application at the Patent Office. The patent application is quite a long, complicated document that describes the invention in great detail. That application is examined by the Patent Office before it's decided whether the patent is to be granted or not. If granted, the patent gives the applicant the right to stop other people from their invention. So that means making it, selling it, etc. But that protection only arises in the country in which the application is filed in. So that means if you get a patent granted in the UK, but your competitor is making that invention somewhere in France, there's not much you can do about it unless you also have a French patent. So it's very much on a country by country basis. Something to remember for all of these types of IP, which I wasn't too sure about until I started this job, was that you don't actually need a patent to be able to market your product. What the patent's there for is to stop other people from exploiting your product. So it doesn't give you the right to sell anything, it just stops other people from selling the same thing. And that means that if you're the person holding the patent for a particular invention, you effectively control the price of that invention in the market, because no one else can compete with you, which is obviously very desirable. The main requirements for getting a patent application granted are whether the invention is novel and inventive. Novel just means that it's new. Obviously, you can't have a patent for something if someone else has already done it. That's not really an invention. And it must be new over everything that has been made public up until the day the application for the patent is filed. So that includes disclosures made by third parties, so published documents, things like that, but also disclosures made by the inventor. This means that it's extremely important that if you're planning to file a patent application, that you don't make your idea public before filing that application. So that means don't put any pictures of it online, don't talk about it publicly, etc. Because your disclosure can be used against you by the Patent Office. The second requirement of being inventive. This generally means that the invention wouldn't have been obvious to someone working in the field of the invention at the time the application was filed. So if your invention is to do with graphics processing, then someone working in graphics processing wouldn't have come up with it, supposedly, if it's said to be inventive. Generally, I find it helps to think about an invention, i.e. something that's inventive, as something that has been designed to overcome a problem. As an example, if you're designing a desk with drawers and you've come up with a new type of runner for that drawer, that means that it opens and closes more smoothly, that no one else has done before. A patent application can be filed to protect the runner, or even a component of the runner. It doesn't need to be filed to protect the whole desk or even the whole drawer. So that's another thing to remember, is that an invention doesn't have to be a big thing. The iPhone, or probably even a pair of Nike running shoes, are likely to have tens, if not hundreds, of patents to every little part of them, rather than a single patent that protects the whole product. So patent protection lasts 20 years, and that's from the date the application is filed. So after that patent has expired, it's then free to use by the public, and it will be no longer infringing the patent protection. The process for getting a patent granted is quite long and expensive generally. So drafting the patent application is the first stage, which, as I said, is quite a long, complicated document that describes the invention in quite a lot of detail. And that's what we spend quite a lot of our time doing as patent attorneys, is drafting those for clients. Then filing the patent application at the Patent Office, that gives you an initial filing date from which everything else is calculated. And then the Patent Office will do a prior art search. And that means just looking at all publications available in that field to determine whether your invention is novel and inventive with respect to those documents. So as I said, those documents could be things that you've released yourself. So it could be if you've put a picture of your product on your website before filing the patent application, the Patent Office could cite that back at you and say that your invention isn't novel and inventive over that disclosure. So this sort of carries on for up to 2 to 4 years, this sort of examination by the Patent Office. So they use the documents they found in the prior art search and send them back to you and say, we don't think your invention's novel and inventive. because of this document, etc. And then again, part of our job is arguing with the patent office to convince them that the invention actually is novel and inventive. So that goes on for a while. If we're able to convince them, eventually after about 3 to 5 years, the patent is granted. So you can see there's sort of costs associated with each of these stages. And the examination can involve going backwards and forwards multiple times. So there's kind of costs involved in all of those steps. And then even once you've got the patent granted, you then have to pay renewal fees to keep it alive. So that's every year from the 5th year since the initial filing date, starting at £70 for the 5th year and then going up to £610 for the 20th year. So you can see that filing a patent application is quite a major investment, particularly for an individual person rather than a large company. So we're going to move on to the types of IP protection that will probably be more relevant to you. Philip's going to talk about design protection and the differences between patents and designs.
Thanks, Anna. So Anna has asked me to talk about some examples around what the differences are between patent protection, so what Anna was just talking about, and another type of protection that we'll be talking a bit more about later on, which is design protection. And the high level summary is that patents are about protecting how something works. And that is often a very complicated kind of analysis, exactly what's new about how something works. And that's a lot of the reason why the patenting process is typically so expensive. Whereas designs are about protecting what the appearance of something is. And design protection is generally a lot less expensive than patent protection, and you can get designs granted much more quickly. So for a kind of typical product where the important aspect of it, or especially where the important aspect of it is what it looks like, design protection is a really good option. And before we talk about an example, it's probably worth just explaining how in these different types of protection you kind of encapsulate what it is that you're protecting, because this is another reason why patents tend to be more complex and costly than designs. With a patent, in order to encapsulate what it is that you're protecting, so that's the inventive part of how the thing works, that has to be written down in what's called a claim. So every patent application will have a number of claims at the end, and those claims define what the invention is. Whereas with a design, it's much more straightforward. You just have some pictures of what the thing is, and automatically you get protection for what's new about those pictures. And as it says here, there are going to be products, ones that have got something new about how they work, and ones that have got something new about what they look like, where you can usefully protect aspects of them with both patents and designs. So on the next slide, if I could ask you to go to that, Anna. We've got an example here, which is a bedside crib for babies, which has an innovative mechanism for folding up, so that if you're putting it in the car and taking it somewhere, you can fold it up easily and then erect it somewhere else so that the baby can sleep in it somewhere else. And there's something innovative about how the legs work, and also there's something new about what the appearance of this thing is. It looks different from other babies' cribs that are out there. And in this picture, we've got the product on the left-hand side, and then a picture from the registered design for this product on the right-hand side. And you can see whether there are two things I would highlight about the picture from the registered design. The first one is that it's a kind of simplified version of what the actual product looks like. So it's very straightforward to take some CAD drawings, for example, of the actual product and use those as the basis for your registered design application. The other thing I would point out is that you can see that the design is kind of simplified in that there are some bits of the actual product that are missing. So the registered design doesn't have the fabric bits. And that's important because the protection that you get from the registered design isn't limited by what the fabric bits look like. So if someone else made a product that had the same frame, or a frame that looked similar to the one that's on the right hand side, but maybe different fabric on it, so different color, or maybe it didn't have that kind of mesh cutout that you can see on the front, or maybe it didn't have the shelf that's underneath the main part of the crib. If it had the frame that's shown on the right hand side though, irrespective of those differences, it would still infringe the registered design. And so the first thing you can kind of draw from that is that the registered design doesn't have to be directed to the specific product that you're thinking about. It can be directed to a new aspect of that product. And the other thing is that when you as a designer have a design that you want to protect with a registered design, you can get much stronger protection if before you file the registered design application, you think about what are the really key bits of the design and make sure that it's only those key bits that go in the registered design. It's perfectly possible to just take photographs of the product and use those as the illustrations that you put in the registered design. But if you do that, then you're going to have more limited protection than you would if you think about it a bit more clearly before you file the application. So this slide shows what you can protect with the registered design application. And on the next slide, so this illustrates, on the other hand, how patent protection works. So it's the same product, and this, all this stuff on the right-hand side is the claim that I was talking about earlier. So the claim in a patent application defines what the scope of protection is. And this claim defines in words what the novel leg mechanism on this crib does. And you can see that it's much more complicated to take the product and distill it into a set of words like this that define the operation of the mechanism than it is to just take a picture of the product and use that as the basis for a registered design application. And this is why patent applications are so much more expensive and complicated than design applications. But the advantage of having a patent rather than a registered design is that this gives you protection for a crib that works in the way described in this claim, irrespective of what it looks like. So it could be triangular or circular. It could have 6 legs or 4 legs or 8 legs. It doesn't really matter. It could be made out of whatever materials you like. It would still infringe this claim if it worked in the same way as is set out in this claim. So for products that can attract design protection and patent protection, you're in a really strong position if you can get a patent and registered design for the same product, because one of them stops people making something that looks the same irrespective of how it works, and the other does the opposite. It stops people making one that operates the same but looks different. Would you like to go on to the next slide, Anna?
Yep.
Is this one of yours?
Yes. So as Philip talked about, you can protect designs using registered design rights. The other route for protecting designs is an unregistered design right, which, as the name suggests, means you don't have to make an application and register it anywhere. It arises automatically. The only criteria being that the design is not commonplace. The downside to this type of protection is that it protects against copying only. So if someone else came up with the same design individually, you'd have no protection to stop them doing that. In order to assert your design right, you have to prove that the third party's copied your design, which is usually quite difficult. Protection lasts 15 years from when the design was created, or 10 years from first marketing, if it was marketed within the first 5 years after creation. In comparison, registered design rights. You must register these with the IPO, as Philip said, with illustrations representative of your design. And as previously talked about with respect to other types of IP, this must be done individually in each country in which you want protection, generally speaking. This provides you with absolute protection. So that protects against individual creation by a third party, as well as them actually copying your design. You don't have to prove that they've copied it, so it's a lot easier to enforce. It lasts up to 25 years, which is an improvement on the unregistered design. The criteria for getting a design registered, similar to patents in a way, it must be novel and also have individual character. Having individual character is said to mean that it creates a different overall impression on the user from everything they've seen before. So if your design creates a different overall impression to everything else that's existed before, then you're likely to be able to get design registered. The actual process for doing this is a lot quicker and simpler than the equivalent for patents. Filing design registration here, it's a lot cheaper, first of all, £50 to pay the patent office for one design. And then that price per design decreases the more you file in one go. The design is then examined within 2 weeks to determine whether it's novel and has individual character. And this examination is definitely not as thorough as the equivalent for patents. It's a lot quicker. And then so either the design is granted or the applicant is given 2 months to respond if the patent office don't agree that the design should be granted. This is quite rare, I think. So yeah, generally a lot quicker and cheaper a process than getting a patent granted. There are also renewal fees, but in compared to patents for which they're due every year, for designs, they're payable every 5 years, up to the 20th year, lasting 25 years altogether. And the cost is reduced in comparison to patents. So I think Philip's taking over again.
Yeah, thanks, Hannah. So what we wanted to talk about now is who owns the rights, which is a really important thing to consider if either you're doing the designing because you want to know whether the rights belong to you or maybe whoever you're working for or whoever's commissioned you to do the design. Or the other way around, it's important to know that if you're the person who's doing the employing or doing the commissioning, because you want to make sure that you've got ownership of the rights. And the way it works is a kind of two-step process. So the law in the UK or whichever other country applies defines who owns the rights first. So when a design is made or an invention is made or whatever else it might be, the law defines who owns that right in the first place. And then that person has the right to transfer the ownership to someone else. Normally, they do that by selling the rights, and they do that through what's called an assignment. And so the critical point to understand is who is the first owner of the rights in different cases. And that depends on what kind of right it is and how the rights have come about. So for patents and designs, the situation generally is that if someone made the invention as part of their employment, which is 9 times out of 10 how designs or patents arise, if someone made the invention as part of their employment, then automatically their employer will own the rights. There's normally something in people's employment contracts that talks about this as well, but UK law sets out a kind of set of rules around this, which mean that in most cases the employer will own it automatically. If you made an invention or a design when you weren't being employed, then you, unless there's some other contract in place, you'll own the rights to that invention personally, and you'll have the rights to transfer those to someone else. There's an important kind of distinction, because there's a third case, which is kind of mostly relevant for designs, and that is where someone makes the design themselves, but they're commissioned by someone else to do the designing. So they're not employed by the person who wanted the design done, they're just commissioned to design maybe a product for someone. That situation is quite complicated, but in a lot of cases, the result will be, unless there's something in the contract where the design was commissioned, the result will be that the person who made the design will own the rights. And so that's important to remember. If you're in a situation where you're commissioning someone to design something for you, you want to make sure that you've got a contract in place with that person that says that you own the rights to the design, because if you've commissioned them to make it, you're going to be in a difficult position if later on you want to sell it and it turns out that you haven't secured the rights to it. So, excuse me, that deals with the situation for patents and designs. For trademarks, it's very simple. For the most part, it's whoever's using the mark has got the rights to it. There are some nuances around that in relation to who filed a trademark application first in some situations, but generally the rights belong to whoever's been using the mark, and that's because trademarks are all about what's called goodwill. So the relationship that Anna was talking about earlier between people's ideas of kind of customers' ideas of what's signified by that mark and the mark itself. So if you see Coca-Cola on a can, it gives you an impression of what's inside it, and so that use by Coca-Cola of the mark gives rise to some rights, and that's reflected in the fact that generally whoever's using the mark or has been using the mark is the person who's entitled to own it. For copyright, it depends on what the kind of work is, because like Anna was saying, you can have copyright in some aspects of physical objects, in documents, in performances, and the who owns the rights differs somewhat depending on what kind of work it is. But in general, for the kinds of things that will affect you as designers, generally it's the person who made the work, the author, who will own it first, subject to any contract that they might have, for example, with their employer or someone who's commissioned them to make it. So that summarizes what the situation is about first ownership of a design. And then, like I said, once you own the design or the invention or whatever it might be, you're entitled to assign that to someone else, and you can charge a fee for that. One other point I wanted to mention here is that you can also, as an alternative, if you like, to assigning ownership in something, you can license someone to use it. And the distinction between an assignment and a license is that when you license it, you retain the ownership of it. So someone will be paying you for the use of it, rather than paying you to buy the actual intellectual property that's protecting it. And so the one last thing that we wanted to emphasize, which Anna mentioned before, but it's really critical to getting protection for designs and patents, is that it's really critical to keep the invention or the design confidential until you've filed an application to protect it. And the reason for that is that if you don't keep it confidential, then your own disclosure of the product or the concept or whatever it might be can stop you getting protection for it. So just to reiterate, it's really critical to decide early on whether you want to protect something, and then to go ahead and file an application if you do want to protect it before you disclose it to anybody. So I think that is the end of the kind of formal set of slides that we've got. We'd be very happy to answer any questions that anybody might have about what we've said, or just generally about intellectual property and how to protect things that you've designed.
Amazing. Thanks, Anna and Philip, for the inspiring and informative overview on intellectual property. Guys, feel free to gather your thoughts, your questions, your comments in the chat. As usual, you can also go live and interact with your questions and sentiments as well. So feel free to do that if you wanted to. Tom Millward's asking a question. So he says he's doing a music-related project for his final major project, and will most likely at some point post videos of how it works to his Instagram, YouTube, social media, etc. So how could he go about getting rights to songs to use them in his videos legally?
Should I answer this one, Anna?
Yes, please do.
Yeah, so this relates, songs are protected by copyright. And the first point to make is that there's an exclusion in copyright protection for what's called an incidental inclusion of one copyright thing in another copyright work. So if you're, I don't know, you're shooting a video and the camera pans and you happen to see someone else's painting that's protected by copyright in the background, but it's just incidental, then that's not an infringement of the copyright in the painting. And the same thing applies to music. So the question for your case, Tom, is whether the inclusion of the music is short enough that it would be considered incidental to the overall work, or is it not incidental and really a core part of the work? Provided it's short enough to be incidental, and there's no kind of numeric cutoff on that. It's a kind of qualitative judgment about how the music relates to the overall content of your work. Provided it's incidental, then you wouldn't be infringing copyright, and you don't need to do anything to get the right to do it. If you want to include a bigger part of it, so it's not incidental, then what you'd need to do is to get an agreement from whoever is the rights holder for that music to put it in your video, and that I have to say isn't my specialist area, but I think I'm right in saying that there's an organization that deals kind of centrally with licensing of music for this kind of purpose. And I think what you need to do, if you think your the bits of video that you're putting in your own work are kind of long enough to not be incidental, then the right thing to do would be to approach them and agree a license with them.
Amazing, thanks for that. And Brady, feel free to go live. You wanted to go live and mute yourself.
Awesome, thanks, Ahmed. Thanks, Philip. Thanks, Anna, for your presentation. It's been very informative. A lot of us, not a lot of us, nearly all of us are students. And so all the design work that we're doing for the most part is done as part of our education. And we're all under the umbrella of the school. If we were to continue forward with some of the designs that we've done as part of our education, where does the rights ownership fall between us and the university in terms of moving things forward with a patent? My understanding is that it's treated somewhat like a employee-employer relationship, but I figured I'd ask the pros.
Yeah, so that's going to depend on what your, I mean, I guess there's some contract between you and the university that governs this kind of thing. And the first thing I would do is to take a look at that and to see how it deals with it. I'm not sure, this is probably a question for the university really. I'm not sure how the university generally deals with these things. I mean, it's not kind of the university's business to, I don't mean it's not their business in a kind of privacy sense, but the university's business is providing education rather than exploiting ideas. So I suspect from the university's perspective, it would be quite happy for people to push those ideas forward after they've left. But do you know more about that, Ahmed?
Yeah, the university does have a policy. So if you Google MDX Uni Student Intellectual Policy, there's a document in kind of covering the intellectual property at the university. So feel free to go through that and read that as well.
Awesome, thank you.
Awesome, great question there, Brady. And next up, Joseph Salem. Joseph's asking, what are the consequences for plagiarizing a design which has a patent or a trademark? Is there a fine or imprisonment?
Do you want to do this one, Anna?
I guess it depends on the creator's position. Obviously they can, it depends how much they care, I suppose. They could do nothing, in which case you'd be fine. But I suppose generally you'd want to resolve things in a friendly way rather than, you know, them taking you to court. So it's probably a good idea to get in contact with whoever owns the rights to a design you're copying to try and negotiate with them. Philip, anything else to add?
Yeah, I think, I mean, generally, if you did copy someone else's design and it was infringing and their rights were valid and et cetera, you're in almost all cases talking about some kind of financial penalty, if you like. And that penalty is generally what the court thinks you would have paid to that person for a license if you'd gone to them for a license. There are some situations in copyright where there are fines and potentially people could go to prison, but they're generally for, in fact, they are, as far as I can think, all for situations where people are counterfeiting things. So, you know, you're selling counterfeit books or videos or whatever it might be.
Amazing, thanks Anna and Phil. The next question from Aurel Marianne is saying, one slide was talking about the unregistered design rights and they automatically arise for designs that are not commonplace. So he was asking, what does commonplace mean in this context, which that word and phrase he didn't quite understand.
I think probably it's quite a low bar. It basically just means that it's not maybe what you'd expect it to look like. But it is kind of open to debate.
Amazing.
I think the unregistered designs are an unusual kind of type of protection because as Anna says, it's a very low bar to actually have some protection. And then the way it works is that the scope of protection that you get, so in other words, how similar something has to be to infringe it, depends on how unusual your design was. So if your design was very, very similar to lots of other things that are out there, let's say it was an item of jewelry like a ring, for example. There are lots and lots of rings out there. Yours will look different in some kind of way, but the protection that you get will be limited to the differences between your ring and generally what's already known in the field of jewelry manufacture. Whereas if you develop something that looks completely like, you know, a new type of games controller that looks nothing like games controllers that already exist, the scope of protection that you get for that will be really broad, because it's in its field much more different from what's already known. So so it's a kind of two-part answer to this question. In order for protection to exist, which is where the commonplace thing comes in, it doesn't have to be very different at all from what already exists. But then the secondary question is what the scope of the protection is, and that's dependent on how different your idea is from what's already out there.
Amazing, thank you. And an alumni, Kushwant Kaspers, he wants to go live and ask a question. Go for it, feel free to unmute yourself.
The question I want to ask is about design rights. And if I did most of the work and took it to a patent officer, what is the expected cost of something like that? If I did the drawings and everything like that, I know you can't put a figure on it, but what should I expect to be charged for some sort of work like that?
Do you want to do that one, Anna?
Do you know?
I think to get it to file it, a typical kind of amount, including so we have to pay some fees to the patent office, but a typical kind of amount, including those fees, is maybe £200 or £300.
Yeah, okay. And the cost from the patent officer as well. I know what the patent will charge, but what would a ballpark figure for a patent officer to carry out such a project?
So that includes what the patent office would charge us. So we have to pay a fee to the patent office to file the application,
right?
And then we obviously have to charge for the work that we do. But putting all that together, if you provided the drawings, it's normally maybe £200 or £300.
Oh, right. Okay. And the other thing is, if there's a slight variant on the actual design, is that a separate design or is it the same design?
Depends how big the variant is.
Right.
So,
okay.
So once you've registered a design,
yep,
obviously something that's identical to your design will infringe it. But things that are similar to your design will also infringe.
No, sorry, perhaps I've said it wrong. So if I've got a design, but I want to have a variant on that design slightly,
yeah,
does the expenditure go skyrocketing, or does that not make that much difference, or do I have to do a separate patent for the variant of it, of the original?
Yeah, I understand where you're coming from. So you don't, as I'm sure you know, you don't have to register the design in order to sell it. You can sell something without having registered the design. So the key question is, do you have, let's suppose you filed an application for the first one. The first question to think about is, has the application you filed for the first one automatically given you protection for the variant? And the reason it might have done is that it's not only identical things that would infringe the first one, but also things that are similar to the first one would infringe the first one. And so if your second one was, in inverted commas, similar to the first one, if it was similar enough that someone making the second one would infringe a registration of the first one, then you might decide that you don't want to file a registered design for the second one because it's not really giving you any extra useful protection.
Amazing.
Does that make sense?
Thanks for the question as well, Kush. And now moving over to Amram Natanal Cohen. He wants to go live and ask a question regarding design versus patent. Go for it, Amram. Feel free to unmute yourself.
Hello.
Hello.
Thank you for the meeting today. It was a great presentation. What I wanted to ask is, would a patent over supersede a design? So if you have a patent in the market, can you have a design protection for that product, or would a patent supersede the design?
You can have both at the same time. They're completely independent.
No, but if somebody has a patent for a product and you are designing a design and you are protecting a design for that product, but in a totally different way of how the appearance looks.
So you mean, would you infringe their patent?
Yes.
So that would depend on whether your product worked the same way as theirs. So if you think about the example that we had earlier to do with that baby's crib, and there was a design on, if you can go to the previous slide, Anna. Yeah, so here's an example where there's a registered design, the product on the left, the registered design is covering the shape of that frame that's on the right hand side. And then if we go to the next page, the claim is setting out what the protection from the patent is, and that's all about how the folding leg mechanism works. And so in your example is a bit like, suppose you want to make a baby's crib that looks different from this one. So if it looks different, it's not going to infringe the design. But if it looks different and nevertheless works in the same way as this one, then it's going to infringe the patent. So if the people you're concerned about have both a patent and a design, then you would need to make sure that your thing both looked different and worked in a different way from whatever it is that their patent covers.
Amazing, thank you. And thank you for the question as well, Amram. Now moving over to Pablo Dejaro, he's asking a question with regards to copyright. So said, you said that you don't need to apply for a copyright, but how can you prove that you created something and someone is, in inverted commas, stealing it? So the question here is maybe ownership, like how do you prove that you were the first for that?
Yeah, so it's a really good idea when you create something to keep some evidence of the fact that you created it. So if you've got some sketches or something, or some CAD files or whatever it might be, it's a good idea to keep those and maybe sign and date them and get someone else who is trustworthy to sign and date that they saw them on a particular day or something like that, so that you've got a bit more than just you saying that you invented it at a particular time. So for, you know, let's suppose you design a new product, you think it's going to be important, it would be a great idea to retain whatever evidence you've got of having developed it, and almost always that will be more than just one drawing at the time when you created it. There will probably be you know, your first version of it and your second version, and then maybe some emails where you asked someone what they thought about it and got some feedback. So there'll be typically quite a bit of correspondence and documentation around creating it, which will be convincing about the fact that you generated it at that time.
Brilliant.
I think that also is relevant for unregistered design protection, because if someone's trying to assert their unregistered design right against you, they have to prove that you copied them. So if you've got your own evidence that you came up with it on your own, then that's useful protection for you as well.
Amazing. And Tom Millward, I think he's following on from the question that he posed previously. He said, thank you for the answer first and foremost. And then following on from your answer, just a little question. What's counted as short enough? So say he was to use snippets from a couple of songs. Would that, what amount would be too long or too short, for example?
Yeah, so there's no kind of, it's impossible to put a number on it, because the test is more about what the impression would be on someone who is looking at the video. Would they think it was a key part of the video, or would they think it was, like I said, an incidental part of it? So you need to consider whether someone would view the part of the song that you've included as being a kind of substantial part of your own video, or is it just something that's very much subservient to the content that you've put into it? There isn't, unfortunately, there's no kind of fixed number for what it might be.
No, definitely. And the next two questions are kind of linked together, so I'll kind of pose them both together. So Joseph Salem, he asks, if you have a design which is similar to another design, but you're unaware that it exists, are there exceptions, or do you just have to do the research? And Navpreet's asking, like, what's the easiest way to find out if there are ideas similar to yours? Like, is there a site or portals or databases where you can see all patents or registered design rights in the UK? She says that this could make it easier to find out if your design is actually innovative or new.
Yeah, there are registers available online, both for designs and patents. So for designs, probably look at the UK IPO's website. And for patents, probably ASPASnet, which is the European Patent Office's register for European patents. Is probably a bit inefficient for patents, just because there's a lot of reading involved to determine sort of how close your design might be to a patent. But definitely for designs, it'll be useful to see what's out there, and you can see easily from the pictures that will be on the register how similar your design is.
And if it would be useful, we could send Ahmed links to those sites, so if people want to do some searching, they can go and take a look.
Yeah, that'd be brilliant. Thanks a lot. And Amram, he wants to ask another question about design protection. Amram, feel free to unmute yourself as well.
Yes, I wanted to know, if I protect a design in a certain shape, can somebody else come and do a different shape for the same product? If it's within the same, so if I create I patent a box, can somebody make a different shape of a box?
So with a design, it protects what the thing looks like. So if let's suppose your box has got an unusual shape, maybe it's got a specially shaped lid, for example.
Yes.
And you protect that with a design. Someone else could, but naturally there's many other shapes of box that people can make, but with that design protection, you'd be able to stop people making boxes that look similar to yours.
Okay.
Is that what you were asking?
I mean, if I have a certain shape, can somebody else look at that shape, make a different shape? In not shape, but maybe a texture or some kind of waves on it, let's say, and make a triangle shape, for example, on the actual box. So like a design.
Yeah, so that would all depend how big a change they've made to it. So we sometimes advise on this the other way around. So if our client, if a client of ours came to us and said, I'm worried that I would be infringing a certain right by making a box of this design, how can I design the box so that it's far enough away from their protection that I'm okay? And let's say they said, what if I put a triangle on the top? What we'll be thinking about is whether the overall impression that the box gives you has changed because it's got that triangle on the top. So if it's this is the kind of thing that it's much easier to explain when you can kind of when you can hold up a product and we can talk about what shape it is. It's quite difficult to do it remotely, but the question is whether, in your example with the triangle, has that really changed the shape of their product, or is it just some kind of bit of decoration that hasn't really changed the character of it?
I understand.
Amazing. And I think the final question then from Kushwant Kaspers is regarding the application. Should they use a template from the patent office or from the design registration?
Well, you can do. Registering designs and patents is one of these. It's a bit like the example I sometimes use is it's a bit like buying a house. There's nothing to stop you doing all the legal stuff to buy your own house, but the consequences might be severe if you got it wrong. And it's the same with patents and designs. There's nothing to stop you filing your own patent or design application, but later on, if you ever want to enforce that and it turns out that you did something wrong or it was too narrow or something, then that is, you know, potentially your protection is worthless. So I would recommend speaking to someone who's an expert in it, that there is a cost associated with doing that, and so it's perfectly okay to do it yourself. The templates that the patent office have are yeah, they give you an idea of how to do it, but maybe a good example. Could you go to the previous slide, Anna?
Yeah.
So if you just followed the patent office template, then I think what someone protecting this crib might do is just take some pictures of the crib, like the thing on the left-hand side, put those in the template and file it. Whereas this particular one, the registered design is that frame that's on the right-hand side. So it's, and the consequence of that, like I said earlier, is that the protection isn't limited to the shape of the fabric and where the mesh window is and all that kind of thing. So if you, and the reason I say this is that it illustrates that if you just took the template and stuck pictures of the product in, they would end up with significantly narrower protection than they would have done if they'd got some professional advice and directed the protection at the really key parts of it. So they have some templates for non-disclosure agreements, and they're okay. Yeah, I think provided they fit the situation that you're in, I'd be fine with people using those.
Amazing, amazing. Thank you. So Anna and Phil, thanks a lot for your talk and taking out the time to join us this evening. So it's been a superb overview on copyrights and trademarks, patents, design protection, and the differences between patents and design protection, ownership and disclosure. So thanks a lot for that. It's been brilliant. And I'm sure all of the students, staff, and participants will echo the same sentiments. So guys, please do stay in touch, and hopefully in the nearest future, post-COVID, if there's an opportunity, we'd love to host you guys both on campus as well. For all of the staff, students, and participants, we really look forward to seeing you all again next week. Keep an eye on your emails for the details of the speaker and the links to the talk. And until next time, stay well, stay safe, and thank you guys.
Great. Thank you.
Thank you.
Thank you.